Good evening and welcome to the October 6, 2020 Governing Board Special Meeting. Our first order of business is calling the meeting to order. Our first of our discussion and action items is 2.1, a presentation and discussion of Arizona conflict of interest law. And Jeff, I'm going to hand it over to our legal counsel, Jeff
Jamie, do we need a roll call?
So it's not on the list, but why don't we do a roll call? Mr. Sylvan?
Thank you, Mr. Chair. That was about to be my next suggestion. Mr. Klinko.
Present.
Dr. Hay.
Present.
Mr. Hanna.
Present.
Ms. Garcia. Mr. Gonzalez. So Mr. Gonzalez and Ms. Garcia are not currently attending, and they informed us this afternoon, a couple hours before the meeting, that they would not be attending. So present, we have 3 board members, which is sufficient for a quorum.
Okay. Thank you very much, Mr. Sylvan. So prior to your presentation, I'm just going to share some board chair remarks about why we're having this special meeting and a little bit of structure and some explanation. Over the last 90 days, there has been numerous information requests and opinions sent by members of the community and board members, Maria Garcia and Luis L. Gonzalez, to the board chair and Chancellor Lambert. These requests and opinions have focused on a number of issues, including Pima Community College's industry partnerships, procurement and RFP process standards, shared governance, diversity, equity and inclusion, governing board protocol, and transparency. The college has provided timely responses to the information requests, and as part of our continued commitment to transparency, we are now and will continue to be addressing these questions and concerns openly and candidly in public meetings with the full knowledge and participation of the community we serve. I want to underscore that spirited public discourse is the bedrock of our democratic system of government, and the board welcomes and encourages public comment at any time, anyone, anywhere from within or outside our college who has concerns about college matters, including but not limited to college policies and practices, discrimination, and unethical and or illegal behavior is encouraged to come forward through the complaint process detailed on the PCC website. The links are provided with this report, which will be attached after I'm completed, including the student complaint process and employee office of dispute resolution. Additionally, as a reminder, per governing board bylaws, Article 10, Code of Ethics, the board requests that all employees to avail themselves of administrative remedies and complaint resolution processes before requesting board involvement. The following statement is not meant to address the underlying questions raised by the communication of any board members, as the board has a formal process to address concerns and respond to complaints. Rather, the following remarks are explicitly intended to outline the board's governance process, including the bylaws and board policy, the Higher Learning Commission HLC criteria for accreditation standards, and the Arizona state laws related to open meeting laws and executive session confidentiality. It is important that the board reminds itself of these standards periodically and commit to following them consistently and educate the public about how the board operates. First, the board governance and adherence to bylaws and policy. The governing board bylaws, Article 12, response to complaints, provides a board-approved process to raise concerns and complaints. The intent of this policy is that to promote the timely and appropriate response of complaints regarding the college and maintain the appropriate distinction between the role of the board and the college administration. Board members shall follow the specific process for responding to different types of complaints as set forth in the board bylaws. It is critical that all members of the board follow this process of the board bylaws. Additionally, per the board bylaws, Article 10, Code of Ethics, B4B3, information requests that will involve more than 4 hours of college staff time per request shall require the agreement of the majority of the board. Moving forward, there will be strict adherence to this standard. Next, the Higher Learning Commission. Going back to at least the 1990s, there has been numerous concerns raised by the Higher Learning Commission related to the board governance. The HLC criteria for accreditation states in section 2C, quote, "The governing board of the institution is autonomous to make decisions in the best interest of the institution in compliance with board policies and to ensure the institution's effectiveness." End quote. Item 4, quote, "The governing board preserves its independence from undue influence on the part of donors, elected officials, other interests, or external parties," end quote. While I and every member of the board appreciate the importance of listening to constituents, board members are elected to serve the interests of the residents of Pima County as a whole, not any particular group, organization, or segment of the populace. HLC accreditation standards require this as well. Put simply, if a board members act at the direction of a specific community member or individual groups, they are not fulfilling the duties of their office or complying with HLC standards. Third, Arizona state law related to open meeting laws and executive session confidentiality. The board has authority only when acting as a collective, and individual board members do not have authority to act on behalf of the college or board. See the bylaws, Article 1, authority, and Article 10, Code of Ethics. Regardless, board actions and discussions must take place at a properly noticed public meeting like the one tonight. Outside of properly noticed public meetings, substantive communications, including 3 or more board members, is prohibited. See bylaws, Article 6, meetings, and Article 10, the Code of Ethics. Also, Arizona Revised Statute 38, 431 through 431.01. Violations of this standard can result in civil penalties assessed against the offending board member and any person who assists in causing the violation. Conclusion. Because of the enumerated issues outlined above, I want to offer 2 specific actions to be taken in the near future. First, we will schedule an upcoming study session and request that our HLC liaison attend to discuss the HLC criteria for accreditation. At the same study session, we will also be joined by a representative from an authoritative public agency, such as the Arizona Attorney General, to discuss the open meeting laws and confidentiality of the executive session, as well as a representative from the Association of Community College Trustees to discuss best practices for governing boards. This session, it will be intended to ensure that all members have an opportunity to have questions answered and to understand their legal obligations and formal expectations. Second, as part of the meeting today, we will determine what additional specific action should be taken to ensure the governing board and by all of its members act in strict adherence to the HLC accreditation standards, Arizona laws concerning open meetings and executive session confidentiality, and the standards and the procedures that have been set by the board. And so with that, Mr. Sylvan, I'm going to hand it over to you to talk about our first item, the presentation and discussion regarding the conflict of interest laws.
Thank you, Mr. Chair. So as you mentioned, a couple of the board members raised some concerns about the propriety of a couple of projects that the college is working on, in particular with respect to the college's work with social tech to develop the Unmuddle web-based platform, and the issuance of an RFP for an energy management and education services and ultimate award of that contract to train. And then recently, there's been a reemergence of questions about the college's decision to purchase the Tucson Inn because you have a connection to some historic preservation organizations. So in response to those concerns, we engaged outside counsel to take a look at all the applicable Arizona laws, college policies and procedures to make sure that these transactions had been handled appropriately and that no one at the college had the type of relationship of any sort outside of the college with any involved parties that would be impermissible in any way or create an impropriety with respect to these transactions. So, and part of the reason that we retained Susan Siegel, who's a partner at Gust Rosenfeld, is she previously served in the Arizona Attorney General's office in the education section and some other pertinent sections, and has spent a significant amount of her career advising education-related institutions. And so what we have is sort of a 2-part presentation to address that concern. So the first is Ms. Siegel was going to provide a general overview of the pertinent policies and procedures, which really, fundamentally, this is a question about conflict of interest. And second, assuming that the board passes an appropriate motion to allow the disclosure of attorney-client communication and analysis, she will then, in the second agenda item, provide a more detailed analysis about how those rules apply specifically to the transactions in question and her findings. And finally, I just want to assure the board, if any board member ever has a concern about whether there's any impropriety or question of an impropriety related to any transaction, we of course want to hear that concern, make sure we understand it so that we can gather the appropriate information and have an appropriate independent analysis done, so that if we are doing something or we discover that something shouldn't have happened, we will take the appropriate steps to remedy it. So I do want to assure the board of that. If there's any questions about that, I'm certainly happy to address those. Otherwise, what I'd like to do is turn the floor over to Ms. Siegel for the overview of the conflict of interest law in Arizona.
Thank you, Jeff. Thank you, members of the board, Chairman Klinko. Andrea, is there a way to start sharing the PowerPoint?
You should be able, do you want me to share it?
Yes, if you would. There, that's right under there, Zoom invites.
There it
Right.
is.
Yeah.
Are you able to see it?
I can see that. You want me just to click on it right there? Can you click on it?
We're just seeing the directory with the document titles. We're not seeing the actual
Okay, sorry, guys.
display.
Seeing her desktop.
Sorry. Yeah, it's not working.
If
What you need to do is end sharing of the desktop and then start sharing the PowerPoint presentation. It only shares one image at a time.
I apologize. Let me try it again.
Okay, there we go. We can then just zoom in on the screen. All right. So let me just begin with an overview. This is a short PowerPoint. It is intended to address the issues that came up in both in all three opinions, if you will. And thank you, Jeff, for your introduction. I have represented both sides of the going on conflicts of interest, both as an assistant AG, as special counsel to Attorney General Goddard, and then in my private practice at Gus Rosenfeld. There have been occasions when, unhappily, I was called upon and have had to render opinions that there was a conflict of interest. And in two occasions, at least one right now, there have been grand jury indictments and no trial quite yet. And of course, COVID has interfered. Conflict of interest is difficult to analyze, but it is decipherable. It is something that you have to walk through and maybe once or twice go back to it for a refresher course. So let's go on to the third slide. The law in Arizona is contained, as far as conflicts, is it contained in this statute, 38503, and specifically two paragraphs, which, and I guess the most important thing to know is that someone who has a substantial interest in any contract, sale, or purchase or service shall make that known and shall refrain from voting upon or otherwise participating as an officer or employee. Section B, paragraph B of that statute deals with having a substantial interest in a decision of the public agency. So A deals with pretty much transactions, you know, contract, sale, purchase, or service. And B deals with decisions relating to any sort of action that in which that employee or whose employee has or whose relative has of substantial interest. Again, for purposes of this presentation, the word of the day, the two words of the day are substantial interest. And we can go to the next one. So the term substantial interest is defined specifically in 38.502.11 as any non-speculative, I'm sorry, I've got to put this, pecuniary or proprietary interest, either direct or indirect, other than a remote interest. Again, the word in your mind that you should take away in addition to substantial interest is non-speculative. Interest, according to our case law, starting in 1972, does not mean a mere abstract interest in the general subject or contingent interest, but is, quote, a pecuniary or proprietary interest by which a person will gain or lose something, as contrasted with a general sympathy, feeling, or bias. And then, of course, in 2002, we have the Hughes and Jorgensen case that said to violate the conflict of interest statute, a public official must have a non-speculative, non-remote, pecuniary, or proprietary interest in the decision at issue. Now, I want to add to you, add to this presentation that the term non-speculative, while it's been used in case law since 1972, has not been in statute. And it was, however, in 2016, 4 years ago, added to comply, if you will, to the case law. There were several attempts of prosecution of public officials, and on appeal, they were struck down, or else they were struck down in the midst of trial because the interest was speculative. It isn't a question of whether you think, ooh, this could happen, that could happen, this could happen, that could happen. That's speculative. If it did actually happen and you know that there's a direct line there, that is non-speculative. Or I'm sorry, yes, that's non-speculative. Could we go to the next one, please? So again, the takeaway, if you were going to take away from this presentation, in addition to substantial interest into non-speculative, it would be what is a remote interest. Some of us lawyers who muddled through, and I did muddle through tax law, I always got frustrated because you'd go to a tax provision and they'd say, well, this applies unless it doesn't. And then you'd go to another page or provision of the tax code and they'll say this applies unless it doesn't. Well, in many ways, the definition of remote interest is that type of a definition. It means an interest that falls in any of the 12 categories that is not of substantial interest. And the Attorney General recently revised his handbook, which he's required to do by statute. And the section on conflicts of interest says that the Arizona legislature has determined that certain economic interests are so remote that they do not impermissibly influence a person's decisions or actions. So that you could have a pecuniary interest, but if it's so remote that it is de minimis, or it could be de minimis, then it falls in these, and it falls into any of these categories, some of which I'm going to talk about, then it's not considered to be a conflict of interest. So if the public official employee only has a remote interest, there is no need for further analysis. Next slide. So I'm going to give you some examples of a remote interest. That of a non-salaried officer of a nonprofit corporation. So if you sit on of a nonprofit organization, that could be an association. It could be, for example, for school board members, it's the Arizona School Board Association. If you sit on the board as an officer, if you sit on the board of the YMCA as an officer, those are remote interests, and the inquiry stops right then and there. E, the ownership of less than 3% of the shares of a corporation for profit. And then it goes into about the total annual income from dividends, which I'm not going to read to you. But the most important clause is the ownership of less than 3% of the shares of corporation for profit. So those of you who've read some of the allegations involving school districts and investigations I've been involved in, we had a situation in one school district where the CFO also owned a consulting company and had more than a 3% interest in that consulting company, and nonetheless participated in decisions to hire that consulting company. Also, her sister had more of that interest, and of course you have the sibling, which I'm not going into in this presentation because it's really not relevant. And F is that of a public officer employee in being reimbursed for his actual and necessary expenses incurred in the performance of official duty. Those are requests for reimbursement of expenses, for travel expenses, food, et cetera, et cetera. Could we go on to the next? So the Attorney General Handbook has a test to determine if a public employee has a substantial interest. And the public officer, or us, should ask, could the decision affect either positively or negatively an interest of the officer, employee, or the employee's relative? Then you go on to number 2. Is the interest a pecuniary or proprietary interest? Could it affect a financial interest or an ownership interest? And then number 3, is the interest something that is not statutorily designated as a remote interest? If the answer to each of these 3 questions is yes, then there's a substantial interest. But if you get down to number 3 and you get to something that's statutorily designated as a remote interest, then the inquiry stops. The next one, next slide. So there's 2 other prohibitions that come up from time to time. I did not find that either of these existed. One is to secure a valuable benefit for the employer officer that would not ordinarily accrue to the officer employee if the thing or benefit is of such character as to manifest substantial and improper influence on the officer employee with respect to the officer's employee's duties. At one point in time, well, if you were given a trip to Hawaii by a vendor, that probably would, it probably would have an effect on the officer employee with respect to his or her duties. But it is, you see that I'm struggling there because it is a subjective test. If I took you to Burger King or if I were a vendor and took you to Burger King for a hamburger, that's not going to have such, I hope it doesn't, would not have such a substantial and improper influence on you. If I took you to Ruth's Chris Steakhouse, maybe not. If I paid an expense paid trip to some elaborate resort, that maybe tip the scales. There's also 38505 that does not allow a public officer or an employee to receive directly or indirectly compensation other than is provided by law and other than he or she would get in the ordinary course of their duties. So example would be getting that trip to Hawaii. That wouldn't be something that would ordinarily accrue and your employer's not paying for it. All right, the next one I think is the end of the slides. So with that, that is the end of my part of the PowerPoint. And of course, I will go into the specifics of the opinions. The most important thing are the words remote, substantial, non-speculative.
Thank you very much, Ms. Siegel. Our next item on the agenda is 2.2, waiver of privilege and release of outside legal counsel opinion for public discussion. Mr. Sylvan, could you read the recommendation?
Thank you, Mr. Chair. If you indulge me for a minute, I just kind of to wrap up that first section. just to let the board know, the questions about conflict of interest have come up from time to time with board members and with staff. And in each case, we do an analysis much like you just heard. And if it turns out that an individual has some connection to a transaction or a party involved in a transaction that might cross one of those lines, then we take appropriate steps to make sure that they're not involved in any way. So it has come up, it's been dealt with a number of times. It's not often, but it does come up from time to time with board members and with staff. So with that, the recommendation on the second agenda item is as follows. The Chancellor recommends that the board waive attorney-client privilege and authorize the release and public discussion of outside legal counsel's opinions regarding potential conflicts of interest regarding the college's purchase of the Tucson Inn site dated March 8, 2019, the ongoing development of the Unmuddle project and related agreements with Social Tech dated September 25, 2020, and the award of an energy management and education program contract with Train dated September 30, 2020. And just for clarification, the dates I read are the dates of the opinion letters from outside counsel.
Thank you, Mr. Sullivan. Is there a motion to adopt the recommendation? I'm sorry.
So moved.
So moved, Mr. Hannah. Is there a second?
Second.
Okay, Mr. Sullivan, would you do a roll call vote?
Mr. Klinko.
So yes, I would like to explain my vote just very quickly, Mr. Sullivan. I just want to I said it in my remarks before. I want to underscore it again. The college and this board welcomes concerns. We are interested in, if somebody has concerns that something illegal, inappropriate, unethical is going on in any way, we have a process, and this board takes them very, very seriously. With that, having an outside legal review and assessment done and making that public is important, I think, to the public trust. And with that, I vote yes.
Dr. Hay.
Yes.
Mr. Hannah.
Can I, just before I vote, can I just verify that the fact that we are taking an action tonight was noticed as appropriately by law?
Yes, sir. And actually, so the motion I read is in the agenda that was published for tonight, that the board might be considering this particular motion. So yes, this was noticed as an action item with the recommendation in the public notice for this meeting.
Okay, thank you. Yes.
Okay. So we have the motion carries 3-0 with 2 members absent. So Mr. Sylvan, would you like to, or Ms. Siegel, would you like to go ahead and give this presentation?
Sure, I'll start. And I'm going to go in chronological order, yes. Approximately a year and a half ago, 18 months ago, I was asked to analyze whether Mr. Klinko had a substantial interest in a transaction concerning the acquisition of properties by Pima College for its downtown campus, so as to create a conflict of interest. The inquiry arose from allegations that board chair Damian Klinko, who began serving on the board in December of 2015, had a conflict of interest when he voted on the district's purchase of 4 properties in 2017 and 2018. And this was by virtue of his previous efforts years before, when he began with his board service, to place those properties on the National Register of Historic Places. At no time did he or any relative have an ownership interest in these properties or derive any direct or indirect economic benefit. In order to render this opinion, I interviewed Mr. Klinko. I reviewed a complaint authored by Luis Gonzalez, a former board member, and its attachments, as well as board agendas, minutes, transcripts, and videos. I have examined, or I did, online materials related to the nomination and placement of these properties on the National Register, as well as corporate documents. I also researched the law and referred to the Arizona Attorney General Handbook. The facts are that Mr. Klinko was appointed to serve on the board in December of 2015. He was elected in 2016 to serve a full 6-year term. And in January of 2018, he was elected chair of the board. and he then and now currently serves. He was employed before he went on the board, he was employed as a contractor serving in the functions of a CEO of the Tucson Historic Preservation Foundation, a nonprofit charitable foundation. Previously, he served as the president of the foundation's board of directors from 2008 to 2014. And he also was the CEO of Frontier Consulting Group, which he owns. The salient facts show that he was hired in 2011. Frontier Consulting was hired in 2011 by the city of Tucson to prepare the Miracle Mile National Register of Historic Places nomination and Arizona State Historic Inventory forms. The project was completed in August of 2013. Neither he nor his employer did any further compensated work on the effort to have these properties placed on the National Register after 2013, I believe. He did answer questions from time to time from governmental agencies and individuals. Then commencing in 2017, the board approved the purchase of different properties, including Tucson Hotel and Resort, Tucson Inn, Frontier Motel, Copper Cactus Inn. Mr. Klinko derived no money from that acquisition. Neither he nor any relative had an ownership interest in those properties. And similarly, Frontier Consulting Group and Tucson Historic Preservation Foundation did not derive any economic benefit. Based upon that set of facts, I concluded that this did not fall within the definition of a conflict of interest. He did not have a non-speculative, proprietary, or pecuniary interest in the district's purchase of any of these 4 properties. Same applied to his relatives. I did that analysis just to cover all bases. No one stood to gain or lose economically by the board's decision to purchase these properties. And neither his employer nor his company, Frontier Consulting, had a non-speculative, pecuniary, or proprietary interest in the district's purchase of any of these properties. For this reason, I concluded that there was no proof available, no evidence of a conflict of interest, any violation of law or district policy.
Are there any questions from the board? Mr. Hanna?
Yeah, 2 things. Ms. Siegel, you did not find that Mr. Klinko had any discussions with the owners of these properties, or that there was any connection between Mr. Klinko and the actual owners of the properties. Is that correct?
That's correct.
Okay.
But the principal inquiry, however, was whether he had a direct, non-speculative pecuniary interest in these transactions.
All right. And there was really no benefit to the Tucson, no monetary benefit to the Tucson Historical Society by the purchase of these properties. Is that correct? Okay. Thank you.
Are there any other questions? Okay, thank you very much, Ms. Siegel. The next item, do you want to move to the next?
Yeah. This one is the opinion dated September 25th, 2020. This involves the unmodel.com platform committee and Chancellor Lambert's involvement in the steering council. Mr. Sylvan asked me to address whether Chancellor Lambert's position and membership on the steering council of the unmodel.com network platform creates a conflict of interest under Arizona's conflict of interest laws by virtue of his employment as the chancellor of the college. He also asked me to recommend possible changes to policy or practice going forward. I examined relevant documents which are attached to my opinion, including the Unmuddle information as to what Unmuddle was. It took a little while for me as an outsider to understand that, but I do think I do now. A memorandum of understanding that was signed for initial services, and the minutes of the inaugural meeting of the steering council. The analysis went very much like I did in my presentation. I analyzed 38503. I analyzed the definition of a substantial interest. I analyzed the definition of a remote interest. Let me go back and point out that Unmuddle is a project or a program that was developed by Social Tech, which is a for-profit organization. The network platform of Unmuddle connects community colleges, students, and employers to provide individuals with learning opportunities intended to increase their employability for career advancement. It also connects employers gives them resources for training their employees and finding prospective employees with particular skills. Those are all evidenced in tabs 1 and 2 of my opinion. The college has a short-term memorandum of understanding with Social Tech that was executed on October 15th, 2019. The amount of this MOU is under the threshold amount specified by board policy 1.05 that delegates to the chancellor the authority to enter into agreements with third parties. That threshold amount is $250,000. Thus, Chancellor Lambert had full authority to sign the MOU, which was less than that amount, far less than that amount. It was $25,000. Social Tech created a 13-member steering council, which according to the document dated January 1st, 2020, does the following. It provides future-focused, and pardon me if I'm a little, a lot of this is education ease, but future-focused strategic leadership, support, and expert guidance on Unmuddle's progress. Council members are not responsible for day-to-day activities and tasks, and instead focus on guiding the vision, leading the field with cutting-edge, trailblazing, future-focused, thoughtful leadership, informing marketplace policies, and providing expert feedback to the leadership team. Chancellor Lambert is the chair of the council. He receives no compensation or direct or indirect pecuniary benefit by virtue of his participation in and membership on and service on the council. He has no ownership interest in either Social Tech or Unmuddle. The analysis again went through what was prohibited under Arizona conflict of interest law. I found that it did not rise. Any of his activities were outside of the definition of the substantial interest. Again, I cited that interest does not mean a mere abstract interest in the general subject or a contingent interest, but is a pecuniary or proprietary interest by which a person will gain or lose something, as contrasted with general sympathy, feeling, or bias. I also analyzed this question under ARS 38504 and 38505, which are the two statutes I talked to you about earlier, and did not find any application of either one. He does not receive extra compensation by virtue of his service on the steering council, and I did not find evidence of any sort of item that he would be given that would influence his decision making. Therefore, my analysis was that Chancellor Lambert's participation on the steering council does not violate Arizona conflict of interest. Now, college policies, you have procurement, purchasing, and acquisition procedures manual, and you have AP 1.25.05. Those follow generally Arizona's conflict of interest laws. And I found that section 1.4 of the procurement, purchasing, and acquisition procedures also incorporates the Arizona conflict of interest law. Since I concluded that Chancellor Lambert's participation on the steering council does not violate Arizona conflict of interest law, my conclusion is also that it does not violate section 1.4 of the procurement, purchasing, and acquisition procedures manual. The same is true with respect to the college handbook. The college employee handbook entitled Ethical Standards of and Conflict of Interest, which was adopted September 11th, 2020. That section also reiterates Arizona's conflict of interest law. And again, since I included the Chancellor Lambert's membership and participation on the steering council does not violate the Arizona conflict of interest law, my conclusion is also it does not violate the college employee handbook ethical standards and conflict provisions. I did, as requested by Mr. Sylvan, I did make a recommendation. I said that I recommend the Chancellor continue to refrain from participating in the negotiation with Unmuddle and our Social Tech, and also refrain from executing a final agreement with Social Tech so long as he participates on the steering council. And I understand that that is the practice and has been the practice. He did sign the MOU for $25,000, which was within his authority. And there is no conflict in him signing that. I just believe that while there's been no violation of the law going forward, in order to reduce the questions that seem to continuously surface in the last 18 months, first with you, Mr. Klinko, and then with respect to the Chancellor, that this would be a good move. Execution final agreement could be done by another authorized college official who does not hold a position with the Unmuddled Steering Committee.
Thank you very much, Ms. Siegel. Are there any questions from the board? Mr. Hanna?
So I'm a little confused as the connection between Social Tech and Unmuddled. Do you have a clue about that, Ms.
Yes,
Siegel?
I had the same confusion initially. Social Tech is a for-profit corporation, and Unmuddled.com is a program Social Tech has developed.
Okay, and is Social Tech a publicly traded company? Do you know?
No,
No, I don't.
sorry to Mr. Hanna. So the answer is no, it's not publicly traded.
Okay.
It's
So
small.
Okay, so there was no indication that there was any other deal made for the Chancellor, that participation in some kind of profits at somewhere else down the line. You couldn't find any evidence of that, correct?
No, yes, I could not find any evidence. And remember, even if not that he did, but even if he did, even if he had an ownership interest in Social Tech, again, the remote interest is less than 3%. He doesn't own any interest in Social Tech or in Unmuddled. One could speculate. Let me give you some speculations. I tried to do the devil's advocate with myself. Well, does this increase Chancellor Lambert's prestige within the college? No, it doesn't. Is this a resume builder? Well, if it was, it still is a remote interest. It's not a non-speculative. Again, I was speculating while I was being the devil's advocate, and I could not find any angle by which I believed the conflict of interest law or college policy would have been violated.
Dr. Hay, any questions?
Thank you.
Okay.
All right, the last opinion was on September 30th. It was my letter. It addressed participation of Chancellor Lambert in transactions or decisions relating to the award of a contract for a comprehensive integrated energy management program. It's my understanding, by the way, just to clear this up, because there seems to be some misunderstanding, there is an ongoing study by Train, which was the successful contractor, but there is no subsequent contract even before the board or closely on the table. And I'll let Jeff address that later on. This is a question as to whether Chancellor Lambert's position on the board of directors of the National Coalition of Certification, which I will call NC3, creates a conflict of interest under Arizona's conflict of interest laws, or policies of Pima County Community College District with respect to the award of a contract to Train US. The relationship is very attenuated, but let me talk a little bit about what NC3 does. NC3 develops certification standards using industry consultants. For example, you've heard maybe over the years the complaint by members of industry, business persons, well, you're churning these kids out but into the marketplace, but they're not properly trained. So the purpose of NC3, as I can tell, is that NC3 gets people together and comes industry and educational institutions. So the industry can say, these are the type of skills that we need an HVAC tech to have, or whoever we're talking about. The board of NC3 consists predominantly of institutions that provide career and technical education. So the question is even more attenuated. NC3 is nonprofit, and Chancellor Lambert sits on the board along with several other people from around the nation, also one from Arizona, that basically are part of the governance structure. He receives no remuneration. It's a nonprofit association. But the most important thing I think in this analysis, before we clog our minds with all of this, is that NC3 has nothing to do with the Train transaction. What it has to do is, on the board of NC3 is an employee of Train. So the question is whether the fact that Chancellor Lambert sits on a board with an employee of Train, does that create of a nonprofit or board of a nonprofit organization with Train, does that create a conflict of interest? And the answer is no. I didn't even need to, I went through the analysis as if NC3 had participated in a Train sort of transaction. It didn't. The whole slim thread is that Chancellor Lambert is a board member, as well as Mr. I believe Archambault, who is on the board of directors. Patrick Archambault, who is employed by Train as Director of Strategic Programs, is a member. So let's analogize it to your local Rotary Club. Say you're on the board of the Rotary Club with a member of industry. Maybe it's somebody that's an employee at Intel. And then you do a deal or a transaction with Intel. Does that create a conflict of interest because you belong to the same Rotary Club or are on the board? The answer is no. So again, I'm not going to repeat my analysis other than to say that it is so attenuated and it's on such a slim thread, there is no way to even approach a conflict of interest. Just to finish, because I took my task very seriously, in all three cases, I addressed, well, what can be done and what sort of recommendation can be made? And I suggested that, I'll read you. Conflict of interest laws are not easy to understand, and recognizing the difference between a remote interest and a substantial interest is key to comprehending how the statute operates and how courts interpret the law. The relevant college policies are fully aligned with Arizona conflict of interest law. Given the number of inquiries and allegations about violations of Arizona's conflict of interest law, I suggest training be given to your board and senior staff on a regular basis. I believe the chair of your board has scheduled such a session in the very near future, which is why we are here tonight in part. And that's the sum and substance of my 3 letters.
Thank you very much, Ms. Siegel. Is there any other questions from board members? And Mr. Hanna has one, and before he does, Mr. Sylvan or Ms. Siegel, could you clarify, just this is around the unmuddle situation, Social Tech, is it a public benefit corporation?
But
So,
they use that term, but it is a private corporation.
right, so to be very specific, so Social Tech is a public benefit corporation formed in the state of Delaware. Public benefit corporation means that in addition to profit motive, they're supposed to consider certain other social values and benefits as part of their mission and criteria for what goals they set. So it's still a for-profit, it's a modified for-profit. And so it's incorporated in Delaware. Many corporations take advantage of the law in Delaware to incorporate there. There's some benefits to doing that. They are doing business primarily out of Texas, where they are registered under the name Social Tech. There was some question raised about that, whether there should be some concern about that. The answer is no. They're doing what they're supposed to be doing. If you're incorporated in one state, but you're doing a significant amount of business in another state, you have to register in that state. Social Tech followed that requirement.
Okay, thank you for that clarification. Mr. Hanna?
Yes, so just for the sake of transparency and just to be clear, there was a lower bid, as I understand it, and Mr. Ward, you can chime in here. There was a lower bid for the train for the, and it's not, as I understand it, it's not equipment. It is the evaluation of our systems plus a design of a hands-on program that would be beneficial to our students. But there was a lower bid, but that's not how all our bids are chosen, or our contractors are chosen. There's a point system. Is that correct?
Well, in an RFP, board member Hannah, when you go out for an RFP, you do not have to pick the low bidder. So I'm not aware of that because I wasn't, I was not on the committee, so I did not see those. But that's just how that works. Is when you do an RFP, you do not have to pick the low bidder if there was a lower number.
Hannah, if it might, sorry, I
Sylvan?
was going to say we have on the line tonight Terry Robinson. He's the director of procurement. So perhaps he could give you an overview of what process was followed. And then if you have specific questions, he probably would be the best person to address them.
Thank you, Jeff. I certainly can. There is a difference between the RFP process, as a request for proposal, as opposed to a bid process. Bidding is a process in which you look for lowest, most qualified bidder, whereas the RFP process, you're looking at multiple evaluation criteria that are scored based upon a look at various proposals that we received. In this case, after evaluating all the proposals, the train proposal received the highest evaluation scoring based on the criteria that our evaluation committee reviewed.
May I also add, I left it out maybe in my haste. I did interview Mr. Robinson, who walked me through that. I did attach the scoring sheet. Amoresco was the second highest and engaged in both rounds. There was a protest that did not raise this issue at all. And the protest was denied and they have not appealed. I did look at some of the bidding documents and the scoring sheets. Every member of the committee in the evaluation committee was required to and did sign a conflict of interest and confidentiality provision, basically saying that they agreed they would not talk to anyone about this and be influenced by anyone, and that they didn't have any interest in that, in the selection of train. So,
So Ms. Siegel, just to clarify or to add to that, so Chancellor Lambert was not a member of the selection committee and did not participate in the deliberations of the selection committee.
right, I was looking, the reason I was kind of stalling is I was trying to find the list. The RFP review and Evaluation Committee consisted of Greg Wilson, committee team leader and college dean of applied technology, James Russell, a college faculty member, Jessica Normoyle, a college program manager, David Clark, college superintendent of operations, and Raj Murthy, college chief information officer. And college senior procurement analyst Jan Pose convened and facilitated the committee. There was no evidence of any wrongdoing based upon my discussion with Mr. Robinson.
Just as a follow-up question, Mr. Robinson, on our RFP processes that we normally, when we issue an RFP, is this the standard practice where a committee is convened of a variety of stakeholders across the college, in this case, senior administrators, faculty, others, to do that ranking?
That is correct. And all members actually, as a part of the process, score independently of each other as they review their roles, as their role is for reviewing each of the proposals received.
And our RFP process, that's outlined in policy, right?
That is correct.
Okay, so we're just simply, we were, and just so I'm completely clear, we were consistent in following our adopted college policy around how this particular RFP was prepared, was issued, was reviewed.
And following our standard procedures and practices from a procurement perspective, sir.
Thank you very much. I appreciate the clarification and then the good work. Is there any other questions? Okay, and one, I just want for just clarification, how many members were on the
Oh, you'd ask me that again after.
I'm sorry.
It was 5, sir.
It was 5, and it included a member of our faculty, a member of our senior administration.
That is correct. It included Greg Wilson, again, dean of our applied technology unit, Jim Russell, instructional faculty, Jessica Normal, and forgive me if I'm pronouncing any names incorrectly, program manager, David Clark from facilities area, superintendent of operations, and Raj Murthy, the AVC for IT.
Okay, thank you very much. We really appreciate it. Okay, I think that concludes this item unless there are any other questions. Thank you, Mr. Robinson. We appreciate you being here, and Mr. Ward. Thank you, Ms. Seagull, for your review of these matters, and Mr. Sylvan. Okay, the next item on our agenda is the discussion of recent board written communication and board members' questions and concerns regarding the Unmuddle Project and Energy Management and Education Program, contract award to train, possible action by the board to authorize further steps to address the issues.
If I might, Mr. Chair, let me just explain kind of what the intent of this agenda item was, and then given our present circumstances, the board can decide how it thinks best to proceed. So based on the various questions and concerns that were expressed, and based on my understanding that all 5 members of the board had committed to attend the meeting this evening, this agenda item was crafted and noticed to allow the board an opportunity to express any questions or concerns they had, and for their fellow board members and for appropriate staff to both address questions and also ask clarifying questions, so that we would all be on the same page and make sure we understand exactly what the questions and concerns are, and then we could determine what would be the next best appropriate steps in order to make sure that any unresolved questions and concerns were appropriately addressed. So unfortunately, because 2 of the key board members decided not to participate, what I had intended to accomplish or help the board accomplish with this item doesn't quite work that way. So, so that was the intent behind this. So I guess a question is whether there are any further questions from the attending board members about these particular matters, or whether there are additional steps that you would like staff to take in order to address these concerns.
Are there any additional questions from the board or concerns?
None for me.
None. Okay. I mean, I think the other important thing to note about this is this document is hyperlinked. It has all of the underlying documents and responses made by board members. You know, again, I think this board has made an effort to be as transparent and as clear as possible. All of our meetings are broadcast. We post all of our agenda material, the underlying documents, and this is a continuation of that. So the public is invited to, go and take a look at these. They look at the responses that were provided by the college and by myself in some cases. This was the opportunity to have any of these questions addressed. I mean, I would like to also, thank the senior staff and faculty members and everybody who took time from their evening to be here to help answer and address questions. These questions have been circling for the past 60 days, and it still has not been clear what the intent of some of these requests, the underlying intent really has been. And this was really in hope that this meeting was to try to address and better understand the underlying concerns. So, we publicly noticed this meeting. The meeting has now been held, and people can raise the questions in alternate ways, but I think the board has now addressed them. Okay, the next item on our agenda is 2.4 future board study sessions regarding compliance with open meeting laws, executive session confidentiality requirements, and accreditation standards for boards. Mr. Sylvan, do you want to read the background on this or share the background?
So I can.
Or actually, no,
I'm not muted. Okay.
This is an action item, right? So
right. So so I can read the recommendation if that would be helpful, and then the board can discuss and decide how best to proceed. And again, the context of this is, again, we had a variety of questions and concerns raised from multiple board members. And so this was an attempt to take at least one concrete step to making sure we were adequately addressing those. The chancellor recommends that the board schedule one or more study sessions focused on: 1, application of the Arizona meeting laws to the board, including presentation by a representative of an authoritative Arizona agency; 2, confidentiality requirements for public officials concerning executive sessions and attorney-client privileged communications, including a presentation by an independent subject matter expert; and 3, Higher Learning Commission accreditation standards regarding board member duties and conduct, including a presentation by a subject matter expert. Each discussion topic will also address the risk to board members and the college for non-compliance with these standards.
Do I have a motion to adopt the recommendation?
So moved.
So moved by Dr. Hayter. Is there a second?
Second.
Okay, discussion on the item?
Could I, yes, Mr. Chairman Klinko. I just want to be sure that I state from my point of view that I value each and every board member, and I value the responsibility that each of us have to ask questions and to, Lord knows I've used that responsibility over my 6 years about asking questions. So that's important, that we respect each other in terms of having that responsibility. But I also understand that in order for us to operate as an efficient governing body, that we have to have some rules in place. And there are not only just rules, but there are laws governing how we act. So I especially welcome us reviewing all those laws and rules as to how we should act as a responsible governing board. So that's it.
So thank you very much, Matana. I mean, I can't agree more. I think this is an opportunity for everybody to get their questions answered directly from the source. I think if you review the communications that have been sent, there's a lot of sort of speculative qualities or statements that discuss different aspects of these things. And I think to have somebody from the organizations or agencies to address everybody's questions and concerns is really probably the most straightforward and best thing we can do. Again, I think it's the most transparent, and I think it's worth, is Dr. Moses available? Is he here this evening?
Yes, I'm here, Chair Craigwell.
One of the things that, I continue to be concerned about, and maybe you can provide a little bit of insight, is over the past 25 years, the college has had a number of issues with the Higher Learning Commission, specifically about board behavior or board actions or inactions. And I was wondering if you could just provide a very, very sort of high level overview of what some of those things have been over the years. I just think for the sake of this conversation, it's helpful.
Okay, sure. I'd love to do that. So first of all, let me just say that under the Chancellor's leadership and based on Higher Learning Commission recommendations over the years, the Chancellor has invested a lot of resources and time in the governing board members being available to professional development opportunities. I think why this is important and why it was important to the Chancellor is because of what you just stated, Chair Klenko, is that twice in our history, the Board of Governors' role and effectiveness and perceived public support has contributed to the college being placed on probation twice. So as individuals like responsible for maintaining the college's good standing with the HLC, I've had conversations with the Chancellor multiple times about ongoingly professional development for the board is a good thing, especially when you have board turnover. So the Chancellor has basically, every time a new board member or new board members have come on, he's invested in those efforts through either basically having the HLC, ACCT come out and ensure that those folks have a good understanding of what their role and their responsibilities are. But dating back all the way to 1984, this has always been an issue for the college. The role of the board, either communication, undue influence, interference, all various natures of things have happened with the boards and over the time that the college has been with the Higher Learning Commission. And again, twice the board's role has come into question, their effectiveness, their delegation of the day-to-day operations to the Chancellor have contributed to sanctions by the HLC. So I think I applaud what you guys are doing as fellow board members and the Chancellor and investing in these efforts, because I think it's a very, very important. I think the college has, in the last 10 years, this is the best position the college has ever been in regards to their accreditation standing with the HLC. And I don't think we need to jeopardize that moving forward. Thank you, sir.
Thank you very much, Mr. Moses. And I would say, this board, and at least some of the members who are sitting here tonight have participated at a very high level of education around HLC standards. We have attended HLC conferences and had multiple sessions with liaisons and representatives. I mean, all of that I think has really provided a very strong understanding of the importance that the commission really plays in assuring our ability to function as highly as we do. And so you would recommend that we have that we bring in our liaison to just answer everybody's questions so that we all hear exactly the same thing and there's no more confusion.
Oh, absolutely, 100%. And she'd be happy to do that. I've already talked to her. She'd be very happy to do that.
Okay, thank you.
Thank you.
Are there any other questions? Okay, thank you very much, Mr. Moses. So with no other questions, if we could have a roll call vote, Mr. Sullivan.
Thank you, Mr. Chair. Mr. Klenko?
Yes.
Dr. Hay?
Yes.
Mr. Hanna?
Yes.
Okay, the motion passes 3-0 with Board Member Gonzalez and Board Member Garcia absent. Finally, we have on the agenda 2.5, a motion to direct college legal counsel to implement the direction given at executive session, and we have no action on that item. So with that, the meeting is adjourned. Thank you all very much.
Night.